Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here today for the submission, or this morning for the submission of 3 cases. The first case is Hall versus Southeast Polk Junior High and others. That case is hereby submitted without oral argument. First oral argument today is State versus Hidlebaugh, and it looks like the parties are ready. Ms. Nye, you may begin.
Good morning. May it please the court, counsel. In State v. Wilborn, this court saved for another day the question of whether good cause exists to solely appeal an agreed sentence without an accompanying sentencing error outside the scope of the plea agreement. And today is that day. This case presents that issue. Mr. Christopher Hidlebaugh and the state entered into a plea agreement by which Mr. Hidlebaugh would plead guilty as charged, and the parties agreed to jointly recommend a suspended sentence if he was able to purchase a house by the time of sentencing. If he wasn't able to buy a house, the parties agreed they would jointly recommend a prison term, and the court was not bound by the plea agreement. Sentencing was then set for about 9 weeks later, and Mr. Hidlebaugh was not able to buy a house in time. The state and defense counsel jointly recommended a prison term, and the court imposed a term of imprisonment. Thus, Mr. Hidlebaugh got the sentence he bargained for. So the question is there good cause to appeal? The Court of Appeals dismissed, finding there was not good cause. Good cause has been defined as a legally sufficient reason, and what constitutes a legally sufficient reason is always context specific. Generally speaking, a defendant asserts a legally sufficient reason or a legally sufficient reason and has good cause to appeal as a matter of right when he's asserting a claim for which an appellate court could grant relief. In this case, when the district court had discretion in selecting a sentence, was not bound by 210 or by statute, but considered an improper factor or an unconstitutional factor, this court can grant relief, and Mr. Hidlebaugh has established good cause.
We weren't thinking when we said that in Wilborn of the specific situation where the defendant is claiming that the sentencing agreement as applied to the facts of the case is unconstitutional, right?
I think definitely we just haven't had this this is a unique situation, certainly, the way this played out. Okay, great.
About Justice Mansfield's observation, is it the claim on the merits that that the agreement itself is what's unconstitutional? The plea agreement
is our claim on the merits. It's not. I think this, I think this is a sentencing issue. I think the plea agreement in itself, as it was laid out, is not inherently illegal or void or unconstitutional. I think it's the way the circumstances played out and the reason that Mr. Hidlebaugh was not able to purchase the house. If it could have played out in a lot of other ways. The inspection fell through at the last minute, or he insisted on buying a house on the golf course, and that was the only house in town he would think about, and there just wasn't one for sale.
Right. The state makes the argument that he kind of limited himself to Perry, and that he could have purchased anywhere, and maybe could have purchased somewhere where they were willing to provide him a place where his criminal record wasn't such a problem.
I think the way that played out, his family's in Perry. Certainly, that's sort of a protective factor that you want for someone who's trying to stay out of trouble. And so his family's in Perry. He talks about trying to stay near Perry, is what he says in the sentencing hearing. He's looking for housing near Perry. And the reason he couldn't purchase a house was about coming up with a sufficient down payment. And so there's nothing that, that he should be looking across the state. If you're sort of talking about sort of the underlying circumstances for why, that maybe he couldn't rent in Perry, that sort of goes to the reasons there they're making this plea agreement in the first place, not sort of how it played out that he wasn't able to fulfill that obligation.
On from good cause, what are the practical implications if we say you can agree to a sentence, the sentence is imposed, and then you can still appeal? Are we going to open the door to a lot of appeals from agreed sentences?
No, I really don't think so. Just from my experience, that usually people who get an agreed upon sentence, their real complaint when they start to appeal is a PCR claim, is something about their counsel, and they tend to fall away for.
This one is?
I mean, I think, he can't challenge the sentencing in a PCR, but, he might have a claim that his attorney, that there was something.
Question. Am I correct that at plea taking, there was no requirement or insistence upon stable housing? It was, you got to buy a house or be under a contract. But at sentencing, prosecution was arguing, we were just saying stable. That's not my read of the plea. Is it yours?
Read of the plea. I think that was everybody's underlying concern, and they maybe misguided. I think this plea could have been crafted in a different way, might have, been done in a way that could have avoided the way this played out, that it raises these constitutional concerns. I think that's certainly what people were trying to get to, but it was not. The plea agreement was you have to buy a house, because it seemed to be, that was this, at that point, the state represented that was sort of the only way they believed he could solve this problem of his chronic, these violations of the registry. But, go ahead.
But you don't think that plea agreement itself was illegal or unconstitutional?
I don't think as it was, because of the underlying reason he needed to buy a house, I don't think it absolutely on its face was unconstitutional, that the plea agreement itself was. I think it could have, if things had, like I said, if they'd played out differently, he was supposed to buy a house and it was some, just some random reason that he wasn't able to, or he didn't try.
In fact, what happens is the district court uses the fact that he didn't buy a house as a reason to impose the sentence that it did, right? Is that illegal?
Because we know the reason Mr. Hidlebaugh got into the record, the reason he didn't buy the house is because he couldn't afford it. It was not because he just didn't try, or he was being extra picky, or, that's what made it, that's what makes this.
So this would be analogous. So the Supreme Court has decided the case with the probation agreement, Bearden versus Georgia, and the court said if you have a probation agreement that requires you to pay money and you can't be sent to jail, even if the agreement's okay, if you're making good faith efforts to comply with the agreement, So your argument is that plea agreement is analogous to a probation agreement. If the plea agreement imposes a financial obligation, it should be subject to same kind of treatment.
Sort of, yes. Yeah, I guess, it's an agreement. Certainly, if, I think that, yeah, I don't know that he could have entered, if the plea agreement had been phrased differently, he was explicitly agreeing to be discriminated against on the basis of his income or lack of funds. I think, if it were more explicit, but stable housing, knowing that that's sort of the underlying motivation, stable housing is a valid sentencing concern, certainly.
The Court of Appeals opinion said 6 months between plea and sentencing. My math, based on the dates of the transcript, is 70 days. Was that a big mistake? Yeah.
Yeah.
All right. I am concerned if this is good cause, and I'm scratching my head at 70 days for, he's not very old. How old is he? 31, and qualifies for court-appointed counsel. And so those things all added up look kind of concerning. But at no time, it appears from the record, was there a request to continue sentencing? No motion and arrest of judgment within 45 days or 5 days before sentencing, whenever that would have been. So there were opportunities along the way to ask for a do-over, right? and those never happened.
He apparently asked his, he put on the record, he asked his attorney to maybe ask for a continuance, and she didn't feel that was, I don't have her statement, I just have his character.
Said something like she didn't think it'd be likely, that it wouldn't happen.
You know, it's been a while, fortunately, since I bought a house, but he was making, what, 20-something bucks an hour. Just gotten a better job. He had been making 13 bucks an hour. It seems to me in 70 days, it would be quite a challenge to save up a down payment for a house.
So, 2 questions, though, about this. Number one, everything we know about his economic situation is just trusting what he says. Is that fair? And so, and I don't think there were any credibility determinations made at the district court, nor asked for any to be made. And that includes the PSI. They take what is given to them. Is that?
Maybe do some verification, I think, in the PSI, yeah.
But, I mean, my big concern about this whole thing is that it is a wraparound guilt attack on the guilty plea. We've got a statute that says, that really limits those, limits them especially when you have no motion to arrest a judgment. That's always an issue. But we also have no reason to believe that he wouldn't have pled guilty, right?
Charged, I don't know, I mean, he didn't get any other benefit for it, except for that they would recommend, right, again, the court's not bound, but yeah.
And we have no reason to know what the state's position would have been without this deal, right? I mean, for all we know, it could have been, he's a repeat offender. It could have been a situation where he'd have no chance to get a probation recommendation unless he agreed to something that might put an end to his problems with housing.
Another fact question, because I didn't see a lot of information about the juvenile stuff, but it's my understanding his first offense is when he was a juvenile, went to Woodward. The victim was 10. So I'm imagining, because I didn't see the juvenile record, he was probably 14, 15, 16 years old when he did that. And then the second offense, the victim was 13, I believe, and it happened in 2011. So the defendant would have been 19, I think. And in Nebraska, that's still a juvenile. And no more offenses of that nature. Everything criminal since then has had to do with registry violations. Is that correct?
Yeah.
Sorry. How do you respond to the argument that this is invited error?
No, I've been thinking about that, and the problem is, it sort of does go to this question about, is this plea agreement wrong? And I guess, I'm sort of pushing that you don't have to find that the plea agreement, that this is only a plea agreement problem. He may have a claim in PCR for the plea agreement, but I don't think it is inherently illegal, but I don't think that takes it out of being a sentencing issue ultimately, because it's still, sorry.
Maybe conceptualize it. If the plea agreement is wrong, is illegal, then it does seem to me there's a problem of why wasn't the agreement challenged and so forth. If the plea agreement is not inherently wrong, but what was wrong was what happened at sentencing, where the district court, and we can argue whether the record reflects this or not, but you contend the district court sentenced him based on the plea agreement without considering whether he had made good faith efforts to comply with that agreement, but was financially unable to do so, the kind of thing Bearden is talking about. Then that would be, it strikes me, would be a different situation.
I think this is still, I think this is a sentencing issue, whether it's invited error, I'm not sure if I'm answering everybody's question. This is not, parties can't enter into an illegal an illegal plea agreement. They can't bargain for an illegal sentence. But there's 2 parties to the plea agreement. This is not just him.
To clarify, what is the requested relief here? Is it for resentencing, or is it to undo the plea agreement and start anew?
Is resentencing where the court, before a new judge, which this is about the integrity of the judicial system, that even if you bargain for the agreement, or you bargain for the sentence.
Saying it's an improper sentencing factor, whether you're a homeowner or a renter? I mean, imagine there weren't a plea agreement and the defendant came to court and the judge said, well, because you don't own a home and you rent, I'm sentencing you to prison.
No, definitely, that plain, it could be that plain.
The agreement, we can just remand it for resentencing.
The way you're arguing it or suggesting it, it would be assuming it's good cause, correct?
You have to, but that's because the relief is a sentencing hearing where proper factors are considered.
The merits issue is a little easier to untangle than the jurisdictional issue.
When you think about any time we've alleged improper factors, or when the court's given a remedy, the remedy is always, if I can wrap up, is a new sentencing hearing, usually before a different judge, and it's about protection of the integrity of the judicial system. It's the defendant never has to show that the improper factor resulted in a higher sentence or that he's going to get a better sentence when he goes back. He just gets the fair, sentencing hearing where proper factors are considered.
One more question, Chief. So I'm trying to think about the district court judge's perspective on this and what the judge should have done at the sentencing hearing. I mean, you've got both lawyers recommending that you follow the agreement of the parties for prison, and should the judge just have said, I'm going to undo this plea deal, or?
Judge, really, if the judge had made it clear that, look, you've said you got stable housing, I'm concerned about, these other factors. The judge still has discretion and still has to, and you can see this judge sort of understands that, explains, I have discretion, I have to pick the best sentence that's going to provide for all these things, but then ultimately says, in light of the plea agreement, which we know is, he only didn't fulfill that is because he couldn't afford the house. And so the judge still has discretion. The judge could say, look, the PSI said, you guys are all recommending prison, but the PSI says you're okay for probation. I think you said you have a stable place to live with your cousin. I'm giving you probation. It could have happened, right? Thank you. I'll see you on rebuttal.
Wenman.
Thank you, Your Honor. And may it please the court, counsel. I want to start with what the Court of Appeals found to be dispositive, which is good cause. And going back to what Ms. Nye said, that good cause, at definition, is something in which this court can provide relief, requires that this court would be able to provide relief. And because of the requested remedy in this case, Mr. Hidlebaugh is unable to find relief here. And I want to talk particularly about this idea that this is an improper factor.
He is, but if we apply Bearden and we say that this was unconstitutional because he ended up in prison because of his financial circumstances, then there is a problem, and there could be a need for a resentencing. So why wouldn't that be good cause?
Justice Mansfield. First off, I think this case is distinguishable from Bearden by its own terms. So in Bearden, the court explicitly says that in initial sentencing, somebody's financial resources is an appropriate factor to consider. The problem in Bearden is that the sentencing court there said the goals of sentencing were not necessarily served by incarceration. And it wasn't until somebody violated their sort of like post-sentencing terms that they were placed in prison. And Bearden is explicit that those are different things. Here, where the court is considering the initial sentence,
Why is it okay to send someone to prison because of their financial circumstances at initial sentencing, but not at revocation of probation?
Sure. So what is important there also is that there was I believe that the law in Bearden was that if you violated those terms, specifically because you were unable to pay a fine, that you were sort of automatically sent to prison. And Bearden says if you have an individualized hearing that states, based on your circumstances, there's nothing other than prison that is going to satisfy the requirements of sentencing here on the back end, that's still appropriate. But also that in initial sentencing where you necessarily have that sort of individualized hearing, that's an appropriate factor to consider, to understand the requirements of sentencing and its goals.
Ms. Nye is making is that it wasn't individualized, that in effect the judge followed the agreement without considering good faith efforts to comply and the defendant's financial inability to comply with the agreement.
Interesting because we have case law dating back before 814.6, like State v. Kaysen, State v. Snyder, that says that by merely giving effect to a party's plea agreement, that's not a true exercise of trial court discretion. That is just giving effect to the plea, to the party's plea agreement, which is why we don't require sentencing courts to give reasons outside of I'm giving effect to the plea agreement, whether or not that's a 210 agreement or not, because Snyder was a 210 agreement, but Kaysen was not, and the same reasoning applied.
None of those responses you gave answered the jurisdictional issue. I understand that you have arguments on the merits, but our standard is whether the defendant has asserted a claim for which relief could potentially be provided, not that they have to win. So
Back to the second prong of my answer to Justice Mansfield, so I appreciate that, which is that if this is an improper factor, resentencing will give Mr. Hidlebaugh no relief because 2.232F1 and 2 requires the sentencing court to consider the recommendations of the parties. And so if this plea agreement is still in place, which there is no challenge to the plea agreement here, this plea agreement will still be intact. If all it is that it is the consideration of the plea agreement that is the problem, that's still going to happen. We're going to be back in the same position.
in front of a different judge where the judge didn't give full consideration, or as I read it, the only reason that the judge did this was because of the plea agreement, right? I mean, shouldn't there just be a sentencing proceeding that's untainted by the defendant's status as a homeowner versus a renter?
I think that it's challenging because if the terms of the plea agreement, which will be in front of the judge, if what we're arguing about is why that recommendation was given or how this played out, then I don't know how it's ever going to be untainted. Yeah.
Judges would disregard improper sentencing material during the sentencing hearing. So judges are frequently presented with improper factors at sentencing, and they disregard them and move on. But here this judge said, I am considering this plea agreement, which means, in effect, he's considering the defendant's status as a homeowner, which, I mean, you would agree that's improper, right? Assume there's a world where no plea agreement and the judge just said, I'm sending you to prison because you don't own a home. Are you telling me that's a proper sentencing factor?
I think if that was like sort of the broad consideration, just you are not a landowner, I could understand where that would be a problem. Absolutely, I don't argue with you about that. But housing status is regularly something that we consider, right? Do you have a stable place to go, especially for somebody?
Considered in this case, it wasn't his housing status, stable home. He said he had a stable home and he had these arrangements and yada, yada, yada. It was the fact that he didn't own a home. It wasn't his status, it was his ownership status.
Argued at sentencing, but it was not a term of the plea. State tried to argue, well, we were just looking for stable housing, but that's not accurate, is it?
No, the terms of the plea were that he would be in a housing contract. I agree, Your Honor.
Donald's question be similar? I'd like to hear that answer again. Assume there was no plea agreement. Would it be okay to say, I'm going to send you to prison because you don't own a home?
I think at a 50-foot view, there could be moments where that would be problematic. I think in this...
First of all, I am baffled how the state would agree to automatically conceding this is good cause. I'm just imagining Pandora's box. You guys are going to be having this thrown back in your face, and we're going to be hearing it. You guys are going to be arguing against it, I imagine, because it's just plain, if this is good cause, I can imagine a lot of cases out there, good cause. Somebody's just going to have to trickle in something constitutional, and we have other cases that say if you're in for a penny, you're in for a pound, then all issues get to be on appeal. So I can just see this being something we need to tread carefully on. Is this really good cause? Now, I think the merits, like I think you can tell from the questions, are, I think, an easier issue to address. I'd like to talk more about the good cause. Why are you conceding this is good cause?
Obviously, in the initial briefing, that was conceded. I would not concede that today, and I understand that that is a challenging position to put the court in, but because it's a jurisdictional issue, the court is never bound by our concessions, particularly in a jurisdictional issue. I had a professor in law school that said if there's a little old man in the back of the courtroom saying jurisdiction, that's sufficient to bring it up, and I understand I'm not a little old man, and that is consistently not the best way to do it, certainly not the best way to do it. But this court is certainly not bound by it, and our argument today would certainly be that this is not good cause and should not be considered good cause.
A new sentence a remedy, even if the sentence might not change, or it could be worse?
No, Your Honor, I don't believe that it is a remedy for the reasons I was explaining.
Or what gets you to that? What authority are you relying on?
Kason and Snake v. Snyder, which precede 814-6, would say that if it's an agreed to sentence, because that's not truly an exercise of the court's trial discretion, but instead giving effect to the parties' agreement, that there's no remedy there.
What you're talking about, so the judge has to at least consider the party's recommendation. What if the state came in and asked for something that was beyond the statutory range? This guy should get 50 years, and he's not subject to 50 years. Would the sentencing court have to consider that?
Then we look at an illegal sentence, which can be challenged at any time. So I think an agreed to legal sentence.
I'm not saying that the court gave that. I'm saying that was the state's recommendation. Would the court have to consider that recommendation?
I do think they still have to consider it pursuant to the rule. And there is a case, State v. Gordon, that was decided by this court not that long ago, 2020, that's cites State v. or US v. Irwin, that I think maybe talks to this, but I might not be perfectly on track here, saying that if the party is looking to get something better by breaching the plea agreement or by challenging their plea agreement, that we don't allow them to do that. So I think it would depend sort of on which side of the spectrum we fall upon, better or worse plea terms. But obviously that plea or that sentence could be challenged at any time, and we would still address it. So I think for the interest of good cause, an agreed to legal sentence, at least which is what is in front of us today, certainly should not be sufficient for good cause.
Because your brief says so. Good cause exists. And then the next step you're saying, but leave it alone. Is that what you're arguing? Affirm the district court on the sentencing?
I am arguing there's not good cause. If I'm tethered to what the brief says, sure.
I am drawn to the fact that you guys conceded good cause in a brief. So okay, but let's say that you're arguing good cause, regardless whether you conceded or not. If we somehow get beyond the jurisdictional issue, are you asking for the court to be affirmed? Okay, and the other side appears to be asking for new sentencing. New sentencing would bring along with it the opportunity for the defendant, if it's 5 days before, to file a new motion and arrest of judgment, right? Is that a concern of the state? Is that why you do not want a resentencing?
No, I think a resentencing is unnecessary. I think that if he wanted to challenge his plea agreement, we would still run into a problem, in part because of what Ms. Nye was talking about here, that there's no real defect. If we were talking about it on appeal, or even I think below, 814-29 would still stand in his way. Apart from some sort of ineffective assistance of counsel claim, I don't know how he would be able to argue, given the plea hearing transcript that we have here, that he wouldn't have entered into this plea agreement but for what was placed in front of him.
What of the argument that the error here was just that the district court focused on the inability to get housing as opposed to some unwillingness to get it? I mean, isn't that sort of the defendant's kind of main argument here? That the district court just didn't focus on his, lack of ability here to, get a mortgage?
I mean, I think if you read the transcript, to me, the court's main focus is what is the agreement, what did you, and what are the recommendations of the two attorneys here? And because both attorneys here are recommending the same thing, can we give effect to that? However,
Holly, isn't that, and there was, I think, Justice McDermott dissented. I didn't join the dissent, but he made some good points, and I don't think we necessarily disagreed with all of them in the majority. The point is, you can't send someone to prison for financial reasons, because if they're unable to meet a financial obligation despite their best efforts to do so. And isn't that what we're arguing about here?
that Macaulay follows the same Bearden line. And if I'm mistaken about that, I understand. But
Bearden's saying it's a probation case. Macaulay's a sentencing case.
sure. And if I recall correctly, it was because they were unable to, I know I have my notes on Macaulay here, but
She hadn't paid.
And the debate was whether she was sent to prison because fines were not having a rehabilitative effect, or she was just sent to prison because she couldn't afford to pay fines. And that was, but both the majority and the dissent kind of agreed it would be improper to send her to prison because she couldn't pay fines.
But I do think in the Bearden line, I understand why we might have some concern about that, but I believe because in the Bearden line, we talk about that if that's an individualized sentencing factor, that the court considers what best sets this person up for rehabilitation, what best sets this person up for success in their sentence.
Now I understand the state is saying that there's not good cause because it wasn't agreed upon sentence. So suppose instead of this housing condition, the condition had been, Mr. Hidlebaugh, you will not be sent to prison provided you come up with $1,000 for the District 5 party celebration fund by the time of sentencing. And Mr. Hidlebaugh didn't come up with the money and he's sent to prison. Would that be a situation where there's no good cause to appeal?
How they are challenging it, because again, we have to consider whether or not there's a remedy. We certainly have bounds for what parties are allowed to request in a plea agreement, right? We have ethical considerations, we have.
It's a legal sentence in the sense, as here, it's not an illegal sentence challenge because what actually happened in the sentence is within the bounds of what's permitted under Iowa law. The problem is what went beforehand to lead up to that sentence. So that's what I'm saying. Are we reading Wilborn too expansively here?
Obviously, there are lots of things that could be concerning in a plea agreement. And there are lots of ways that a defendant can challenge their plea agreement. And if they don't do so, then they have an opportunity to challenge the counsel that they were given through a PCR. But I don't think that that necessarily makes a sentence problematic, right? By pleading guilty, you waive your challenges other than the sentencing. And the sentencing court, I mean, consider if all of the factual basis, if I may finish, Justice Christensen. Imagine if the sentence, or if all of the evidence against somebody was collected contrary to the Fourth Amendment, and yet they still agreed to plead guilty. We wouldn't hold the sentencing court to consider how that evidence was collected, right? I'm not saying that there would never be a way for somebody to remedy this problem. I just don't think the requested relief here will do so.
Why isn't a new sentencing hearing that's untainted by an improper consideration relief?
Because if all that the court has to do is consider the plea agreement, it will always be tainted, right? And they have to consider the plea agreement under 223 F1 and 2.
A judge on resentencing could decide not to send him to prison. There's a potential for relief. I don't understand that.
Not to mention motion and rest of judgment.
Sure. The judge deciding a different sentence, I don't think takes away what they're saying the problem is, which is the consideration of the factor.
Here today, if the judge had entered into a line of inquiry like they did in Macaulay?
No, but I think somebody choosing to appeal and somebody still having the problem is still existing are two separate considerations.
So we just removed a judicial officer for using the term wetback in a courtroom. So let's imagine you had this sentencing hearing and the judge says, I'm going to be bound by the plea agreement Plus, I don't like wetbacks. Are you saying that the chance for us to police the integrity of our court system and make sure that this defendant is entitled to a sentencing hearing that's not tainted by improper factors isn't relief? Why isn't this the same kind of thing?
Because I would assume that that person's ethnic background would not be a plea factor. And so having a sentencing that didn't rely upon that, which is outside of the plea agreement, not dictated by the rules certainly, would allow for some resentencing remedy.
It's all the same piece. It's either a proper sentencing factor or it's not. So if you can't consider race and you can't consider home ownership status and you can't consider XYZ, I don't see why having an untainted sentencing proceeding isn't some relief, even if it's ultimately the same result.
I suppose under this court's own conversation about what relief looks like, I think then there is a meaningful difference there of what the court brings in its own problematic considerations, as opposed to what the parties have put forward as a requirement of their plea agreement. And realistically here, what the court considered was not his home ownership. It was what his recommendation was pursuant to the agreement of the parties. And I do want to be clear that even if we move into equal protection, there is no law putting him in a classification, right? He put himself into this class. He made this agreement at an arm's length with the state. And so to now say, I got an outcome that was not what I asked for, or is exactly what I asked for by placing myself into this situation, I think just generally speaking, doesn't fit into our equal protection analysis to begin with.
Seen such a plea detail like this one in your career? Got to own a home or you're going to jail? Because that's really what it boils down to. That was the plea agreement. You got to own a home or you're going to jail. Have you ever seen something that extreme?
I certainly do not have the longest career in this, and so I don't know that I've seen enough things to know what's normal or not, but sorry.
Case.
But I think for this defendant in particular, who has struggled to stay in one place and report where he is going to be, and if you read that plea agreement, it says, I think this is my best chance to be successful moving forward.
I agree, but that wasn't the conversation.
But I think if you read sort of the details in the background with where he says he's not been able to rent and he has housing then where he's staying with somebody, or it's sort of out of his control, to say, okay, if you can find a place where you are the person keeping yourself there or not keeping yourself there, it then becomes a pretty relevant factor to if he will be successful moving forward in not violating the terms of his probation and not violating the terms of the sex offender registry. And so if you take these facts, broadly speaking, I understand that they don't seem great. I think if you look at the specific factors of this person, which is what sentencing is called to do, right? Make individualized determinations. I don't think anyone was trying to do anything nefarious here, but I do understand, and the prosecutor recognized that it's a pretty extreme remedy.
Could I ask one more? Just to make sure the record's clear, is the state conceding that considering whether or not a person owns a home is an improper sentencing factor? Or is the state just conceding that if you made your sentence just about that housing status period, that would be improper? Okay, thank you.
Of the state? Okay, thank you. You may be seated. I'm going to hit you with a question right away. Would we be here today if the district court judge had engaged in an inquiry as to, tell me more, did you make application? And what if the testimony was, I did nothing. I never made one call to a banker. I never looked for a place to live. I did nothing for 70 days. Would we be here today?
Honestly, I mean, if there's, if the court had done that, I mean, would I still be making some kind of argument on appeal? Would I have got, but it would be a very different argument if the court, if there was different evidence in the record, if the court had made it clear, somehow had figured out, I just don't think you have stable housing, and that's why I'm sending you to prison, relied on valid sentencing concerns to send him to prison if it were.
In this case, based on what I can see, that would not have been a finding, because it did appear he had stable housing, correct?
He asserted he had stable housing. He had his cousin in the courtroom. She owned her home. So he wasn't going to have this sort of renters, problem of living with friends that rented and then, leases expire and he can't stay on. So he assured the court he had stable housing. He had a job, a good job, and was working towards the down payment, but just
Considered 10 things and said all 10 things out loud. I'm considering you have a job, or you don't have a job. But anyway, and one of those things was, and you don't own a home. Is that an improper sentencing? If that was one of the factors he says he relied on, is that you don't have a home with 9 other.
Yeah, I think that would be improper. I think, and the court has said, if there's one improper factor, we don't look at whether that's the one that carried the day and changed the sentence. If it's in there at all, we send it back for a new sentencing. Yeah.
Make sure I understand. So you can consider employment circumstances, right? I mean, you have to consider that, right? The PSI talks about where his money's coming from, where his bills are getting paid, whether he's done bankruptcy, whether his wages are being garnished, whether he owes child support. All those things are permissible, right? Had public assistance and whether he gambles. Those are all in the PSI, all permissible, but it's still impermissible to consider whether or not he owns a home or not.
Just ownership, just based on, I think that, and it's just, you can consider, you assume, all of those things could be the employment, that could be used in a way that would go to, improperly to his finances, to his finances. But on the surface, you're looking at protective factors. What is this person's chances of success on probation? How are they gonna do? And are they trying? And so you're looking at all the circumstances, certainly, yeah. I guess, just quickly, as far as, Chief's concern about the floodgates being opened, I think Wilborn has already done that. If there had been a fine in this case that wasn't agreed to, you've already got this, that once good cause is established, you have jurisdiction over the entire appeal. But I don't think the floodgates will be further open, because generally, if we had in a case where there was where the plea agreement didn't end up being the problem, but a perfectly legit plea agreement that played out in a normal fashion, and then the court said, I'm relying on the plea agreement, and you've got the sentence, you get the sentence you agreed to, and there's no extra, the court doesn't say anything else, I don't know what I'm gonna argue on appeal. You need the improper factor, that it's sort of Justice McDonald's example of, I'm going along with the plea agreement, but then I'm going to throw in, I'm really happy about it because of your race or your gender, right? So I don't think that this is going to open the floodgates any more than they're really open. And I just disagree that he's put himself in this category. He agreed to the plea agreement, but the reason he didn't fulfill the plea agreement was about a lack of financial ability, and he clearly is trying everything he can, so it's not that he invited this discrimination on the basis of income.
But there was no inquiry into that, correct? Is that an assumption you're making?
He said, excuse my language, I'm busting my ass, as he explained how he's working doubles, he's gotten better jobs, he doesn't quit a job without having another one, he's secured stable housing with his cousin, so yeah, there's nothing to contradict.
Considered part of the allocation, wasn't it? Yeah.
All right.
Boy, I'd like to explore how this may play out. If we agree with you, there's good cause, and we remand for resentencing. At resentencing, he explains and there's a good record. He can't afford to buy a house despite his best efforts. Then is the trial court or the sentencing court required to impose probation?
I don't think so. I mean, he explains that if the court says I still exercises its discretion and still thinks prison is appropriate for appropriate reasons, not just because you can't buy a house, but because of whatever other reasons exist, there's no guarantee he's going to get a better sentence. There never is. I wish there was, but that's never the way it's worked. Thank you.
Hidlebaugh is hereby submitted.